Now that we have an understanding of the words terms, conditions, and warranty, we can go on to start thinking about how we differentiate between terms, things that are actually included in the contract, those obligations that arise once we form a contract, and other things that happen, which we're going to call representations. And this diagram helps us understand some of the ways we can think about terms and representations. So the first thing that you can see is that we have two different kinds of statements being made, those that give rise to obligations and those where there's no obligation. And as we said in the last video, that is what differentiates a term from other things that are said during the negotiation and contracting process. And for the rest of this video, we're going to classify them as representations. Now again, it doesn't matter whether they're in writing or whether they're verbal. So if I said I was going to sell you the best steak in Brisbane, well, I could tell you that, or I could write that, for instance, on an A-frame advertising board out the front of my butcher shop or restaurant, etc. So it could be written down or verbal, it doesn't matter. And that idea, as we said in the last video, of a best steak in Brisbane is generally going to be considered puffery and not a term of the contract. So the conceptual point for us here is that whether something is a term or a representation doesn't actually depend upon whether it's stated verbal or whether it's written down. We actually apply some legal rules that we're going to go through to determine this differentiation. Now, the other major thing that you'll see on this diagram is that within all of our terms, we have two kinds, express or implied. Express terms, as it suggests, are those that are expressed or clearly communicated by the parties. Again, that could be written down or it could be verbal. But not all terms are express. Some terms are implied. And in fact, I could actually probably put another box here which is implied by the parties' conduct. So let's discuss these implied terms. First, I'm going to say that this is a rather complex area of law, so it's notable in our particular subject, but I think it's really important that you understand that they're here. The first one that I'd like to deal with is terms imposed by statute. So for instance, the Australian consumer law has a series of terms that are imposed on consumer contracts. So for instance, goods must be fit for purpose. I won't go into detail about what these terms are. Just realise that if Parliament writes a statute that says in certain contracts these terms form part of the contract, then they're in the contract and the parties can't get out of them. That term is implied by statute. Now, in much the same way, over many years, the courts have developed a series of terms that they imply under common law. And in fact, many of these are the basis for what Parliament takes up and turns into statute. So, for instance, if you buy a cup of coffee, there's no express term that it will be drinkable, that is, that it won't poison you. However, the courts will imply that term. Again, I'm using the same term, but there's a common law term that goods be fit for purpose. So not everything that is a term actually has to be expressed. Things, for instance, that you might take for granted, that you can drink a coffee, will be a term of the contract. And then sometimes you can look at what the parties are doing and imply that there's a term. Again, this is probably the most difficult area. You have to be pretty sure that they implied that term, especially when they may have written down other terms. Like, why did they not write it down would be the question the court's asking. It would have to be so obvious. So if there are things that are obvious, things that are normal in that kind of business, or things required by statute, they can become obligations under the contract via implied terms. But as I mentioned, for the rest of this module, we're going to concentrate on these express terms. So sometimes it's easy to tell what the terms of the contract are, particularly if you have a signed written document that contains the whole of the agreement, then your terms are pretty clear. But at other times, it's not so clear. It could be a mix of express terms. Some might be written down, some might be spoken. Then there might be some that are implied by statute. So to get a full understanding of what our obligations are, we have to be able to differentiate these obligations, these terms, from representations, other things that might be said or written or implied during the negotiation process. So express terms are those that are either written down or stated. So a contract could have all the terms that are verbal, all the terms could be written, or the terms might be a mix of the two. Because these are terms, they're an obligation on the party that promised to do them, and if they don't do them, then there's a breach, which leads to a remedy, something we'll talk about a bit later. So to work out there's a difference between a representation and a term, we're going to use a combination of three rules. The first, the parole evidence rule, is dealing with situations where we have a written contract and someone is trying to get a statement made prior to the formation of the contract into the written document. They're trying to say, is this verbal statement over here a term of the contract when we have a written contract? That's the parole evidence rule. The second one we're going to deal with is what happens when you have a signed written contract, there's a statement in it. Is that part of the contract? That's different to try and get a verbal statement in. So that's the parole evidence rule. Then we've got if it's written in the document, is it part of the contract? And the third is how do we determine if verbal statements form part of a contract when it seems to be partly in writing? Or even which verbal statements form part of a contract? Does everything you say during a negotiation when it's a verbal contract form part of the contract? Or are some things in and some things out? And how do we work that out? And we're going to use the test in Dick Bentley. So let's go through those in more detail. As you can probably tell, sometimes it can be hard to work out exactly what parties have agreed. We can say, yes, they agreed, but it might not be clear exactly what they agreed to. That's one of the reasons why people talk about having your contracts in written documents. Why? That gives you clarity obligations. Not all the time, but it certainly really increases the chances that the terms of the contract are clear. So what you can see is that there's almost a hierarchy in the clarity of terms or obligations that the parties have. At the top, we have a signed written document. If you've got a signed written document, and you've gone to that trouble, then it's highly likely that this contains all the agreed obligations, right? So it's clear and certain as to who should do what. Now imagine you've got a written document. Now that written document could be an exchange of emails, could be something written on a napkin. It could be a contract that's been drafted but not signed, and then you agreed with a handshake. Now, in these situations, it's clear the parties went to some trouble to clarify what they were agreeing to, but there may be some other things not documented, or maybe they don't totally agree on what's written. Now, if we take it for granted that the evidence shows that they agreed to whatever was written down, then the question is not so much what was written, but what else was agreed to. If we've just exchanged a couple of emails, does that mean that any verbal statements that we make as well aren't included? Or even better, when you're making notes on a napkin at the pub, is it just what's written on the napkin? While it might be clear what is written down, it's not clear what else might be a term. And then finally, the hardest to be clear about are verbal statements. Verbal statements made as you negotiate could be part of the contract, or they might just be part of the negotiation process. So this is where it can be more difficult to work out what you've actually agreed to. And this is one of the key drivers behind that piece of advice, particularly for any important contracts to have a signed written document. It's so that you can be clear on the terms. So the first rule that we want to deal with is the parole evidence rule. Parole was Latin for oral. So it's really talking about the oral evidence rule. So this rule applies when you have a signed written document that is the whole of the agreement. So if you've gone to lawyers and got them to write it all up and their lawyers have checked it and you both signed it, I'm pretty sure that's going to be the whole of the agreement. And most times, if you have a signed written document, the courts are going to say that's the whole of the agreement. If you went to the trouble of writing it down and signing it, you should have put any terms that you wanted into that document. The parole evidence rule says if you have a signed written document that's the whole of the agreement, nothing anyone says during the negotiation can be a term. Oral evidence is excluded as a term of the contract. And that's the message I'd like to leave you with. Be very careful about signed written documents. Make sure that what you want is in that document, because if it isn't, it's very, very difficult to get what was said into the contract as a term. I have some exceptions in the last paragraph there that I'm not even going to mention in the video because I think they're quite difficult to actually show. So, signed, written, whole of the agreement, statements can't get in. Verbal statements can't get in. That means if there's a conflict or inconsistency that's written in the document and what someone said or promised during the negotiation, the courts disregard the verbal representation. So they rely on what is written. Now, the parole evidence rule applies when a written contract appears to be a complete record of the agreement. So we're not talking about a couple of dot points noted on a napkin or a couple of lines of email exchange. That doesn't generally look like a complete record. But if the document looks like a complete record, you can't get those verbal statements in. It is sometimes possible to show that a document isn't the whole agreement, but that's very hard to do. So I want to leave you with the message, signed written document, make sure the terms are in there. And in fact, many contracts now contain what's called a whole of agreement clause. What that means is the written document has a term that says the document is the whole of the agreement. And if that term is in your document, no verbal statements can actually get into the contract. Okay, so that's an introduction to the difference between representations and terms, the difference between express and implied term. In this module, we're concentrating on express terms. And then we started down the path of differentiating between a representation and a term. And the first thing that we dealt with was the parole evidence rule, which says if you've got a signed written document that looks like the whole of the agreement, verbal statements can't get into that document. They can't be a term of the contract. And we're going to continue on differentiating between a representation and a term in the next video.